over to you, Alex.
Brilliant. So, Mary, if you don't mind getting your slides up or getting the slides up, then I can unleash, as it were. But just while still doing that, thank you so much for the invitation to speak. It's very kind of you to let me stick my oar in from south of the border. And I should make it really, really clear. I am brilliant. There we go. Thank you. So just then we're on slideshow. Let me just cool. Thank you, Mary. Brilliant. So let's start with that one. So make it very clear. I'm giving a talk from the perspective of England and Wales. I'm an England and Wales qualified barrister. I am not Scots law qualified. I have a really strong interest in the law in Scotland, partly because for all sorts of reasons. One of the reasons being that I sit on the Law Society of Scotland's Mental Health and Disability Committee. I've been allowed on, which is very nice of them, because I find it incredibly interesting seeing how two jurisdictions either side of a border approach similar questions in really some quite fundamentally different ways. So I am very, very, very much not intending during the course of this talk to suggest England and Wales have got things right and everybody else should do things our way. I'm incredibly conscious when I'm giving talks in this area. That's not what I'm doing. What I'm trying to do is flag up some areas where we do things differently so that we can have a discussion about how we approach the same questions in different ways and what that might illuminate. So in order to do that, what I want to do, I think I need to walk through mental health law very broadly defined in England and Wales. And so I'm not just talking about our Mental Health Act 1983, the equivalent of the Scottish 2003 Act. I'm also talking about our Mental Capacity Act, which is essentially the equivalent of the Adults with Incapacity Act. I don't feel too bad about using the term mental health law in an incredibly broad framework, incredibly broad way, because the Scott review of mental health legislation under the way at the moment in Scotland under the chairmanship of John Scott. There are too many Scots in that sentence, but the Scott review, so I might just ask you to go back for 1 second, Mary, sorry. The Scott review uses the term mental health law very broadly. I might not necessarily use the term mental health law to cover what I might think of as incapacity law, but the Scott review is using mental health law to cover both, as it were, law relating to people with mental disorders and the law relating to the situation where a person who may or may not have a mental disorder is not in a position to make their own decision. So I'm using that term very broadly. So next slide, please, in my best Chris Whitty way. Starting with the Mental Health Act 1983, this is a very, very old piece of legislation in its bones. Its bones are the 1959 Act, which in turn was based on a very interesting piece of work done by the Percy Commission, a royal commission just after the war. And I always find it useful when I'm teaching about this to remind people that previous generations aren't necessarily just evil old dinosaurs. What's fascinating about the Percy Commission back in the 1950s, leading to the 1959 Act, which, as I say, is the bones of the 1983 Act, the Percy Commission were driven by the idea of parity of esteem. You should, in other words, be able to enter and receive treatment for mental disorder in a mental health hospital on essentially the same basis that you would enter and receive treatment for physical disorder in a physical health hospital. You don't need some formal admission procedure for the latter, and the Percy Commission thought, why do we need a formal procedure for the former? In circumstances where prior to then, people had really only ever been able to get into what were called lunatic asylums through a very, very formal procedure. So there was a very interesting model of informality baked in 1959. That model came under serious pressure over the 1970s in particular and 1980s, but in particular in the 1970s, with lots and lots of civil rights lawyers in particular, people like Larry Gostin, an amazing American lawyer, doing lots of work for the mental health charity Mind, saying, yeah, well, informality is all very well, but we need to have more structures in place, because actually one person's informality is another person's abuse of power. Potential abuse of power is one way of thinking about it. So we've now got a structure in the Mental Health Act 1983 in our zone in England and Wales, which really operates on the basis of detention first, challenge afterwards, which is very different to Scotland. Because in Scotland, is a very crude characterization, the model should be tribunal looks at you first and decides whether or not detention is appropriate. And you may have situations where it's not detention in hospital, it is provision of treatment within the community from the outset. England and Wales does it on the basis of a multidisciplinary assessment, so not just medics, an approved mental health professional who's not meant to be, is not a medical practitioner. So effectively administrative authorization of detention, and if somebody doesn't like it, they can challenge afterwards. We've also got community treatment powers akin to, well, not akin, but Scotland's got community treatment powers. In England and Wales, you have to go into hospital first and then can be discharged on a framework or sent out into the community on a framework. So it's a different model. One other thing just to get out of the way, partly just linguistically, it's terribly confusing sometimes having conversations between English and Welsh lawyers and Scottish lawyers, because guardianship means something completely different to us. Guardianship in England and Wales is a very limited power used now. I think there's something like 100 and something people on guardianship in England and Wales. That's a provision under our mental health legislation, which gives somebody, normally a social worker, a power in effect to say where someone should live. It's not the equivalent of guardianship in Scotland, which is a much more, it is essentially a much more wide-ranging decision-making power granted by a court. So I think that's probably just enough on the civil structure. Just next slide, please.
It's
sorry, Mary. Brilliant, thank you. Just to say, we do have a criminal structure, quite often called the forensic system. So in other words, that is sending people into the mental health estate from the criminal justice system, either pre-trial, post-trial on conviction, or much later on transfer from prison because the person's mental health condition is deteriorated. So the pre-trial or post-trial is essentially where the person is considered, for whatever reason, either not to be culpable for the offence that they might have committed or not fit to stand trial. It's more complicated getting people out of the criminal justice system because it's not just the responsible clinician, so the clinician in charge of the person's care. It quite often will involve the Secretary of State to well, effectively take account of public interests at stake.
Yeah.
So Mary, I wonder, I think it might just be you who needs to mute yourself, actually. I think it's either you or somebody else is unmuted. I'm just wondering whether it might be you. And I wonder if I could just then possibly ask for the next slide, please. Sorry to make you do all of this. So I just thought it would be helpful also just to give a sense of what's going on numbers-wise in England and Wales. So this is the most recent set of stats, NHS Digital. They were published about a month ago. So these relate to 2019, 2020, obviously taking into account some of the period of the pandemic. So we've had 50,000 new admissions, 51,000 new detentions recorded. It's quite complicated sometimes trying to work out precisely how many of those are, as it were, repeat detentions. We've then got 4,650 patients placed on community treatment orders. So those are people who have been in hospital and then their responsible clinician, in conjunction with an approved mental health professional, have placed them in the community on this framework for community treatment. What I wanted to emphasize particularly, though, were those two bottom bullet points. Because whenever I teach, whenever I do anything in relation to this area, I think it's incredibly important to locate the law in a wider context, because you can look at the Mental Health Act, you can look at in England, or it's a counterpart in Scotland, and you actually need to do a lot of translation work between that act and how individual people are being considered. What is absolutely astonishing is a polite way of putting it. Just look at the third bullet point. Look at that, known rates of detention for Black or Black British group, over 4 times those of the white group, and over 10 times the rate for the white group for CTOs, so community treatment orders. Never in Scotland, please don't think, well, CTO means something different to you in Scotland. CTO here, community treatment order, is that framework within the community. 10 times the rate. I mean, that is just astonishing. The Mental Health Act review in England and Wales was set up in large part to try and work out why the Mental Health Act was being used so disproportionately in relation to people, in particular Black or Black British. Very, very challenging indeed. The last bullet point on that page is very interesting, and it's particularly disturbing. This is the first year, 2019-20, that the stat was gathered. Detention in the most deprived areas have the highest rates of detention in the most deprived areas, over 3.5 times the rate of detention in the least deprived areas. So everybody knows at one level there are the social determinants of mental ill health. That must be telling us something, that bottom statistic, but that is really, really challenging. So, I mean, it'd be very interesting to learn what the equivalent stats are in Scotland. I probably should know, and I probably should have gone and looked it up, but I just think it's very interesting from an English and Welsh perspective. We're not just talking here about mainline black letter law, we're talking about how it's being implemented in practice. So next slide, please, Murray, if you wouldn't mind. So that's the stats. So sitting alongside the Mental Health Act, we've got the Mental Capacity Act. And so the Mental Capacity Act is built on a series of things. And I just want to sort of run through them with you because they're actually quite fundamentally different in some ways to the provisions of the Adults with Incapacity Act in Scotland, with which you may well be familiar. So in England and Wales, well, one similarity is both pieces of legislation have got principles. We've got 3 principles relating to capacity, how to think about decision-making capacity, 2 principles relating to best interest, which is the test we apply to determine what should happen where somebody doesn't have capacity to make a decision. We both have a similar-ish sort of test in relation to determining whether or not somebody's got capacity to make a decision. We've got a functional test. Can the person understand, retain, use, and weigh the relevant information? And if they can't, why can't they? It has to be down to an impairment or disturbance in the functioning of their mind or brain. We then have best interests. Some of you may well know Adrian Ward, a fantastically good lawyer in Scotland, and basically the creator of the Adults with Incapacity Act. I mean, along with other people, but he was the really driving force. Adrian and I have regular discussions about the extent to which best interests in England and Wales, how that meshes, if at all, with the concept of, for instance, benefit under the Adults with Incapacity Act in Scotland. There's an article, if you're interested in reading it, there's an article in the International Journal of Mental Health and Capacity Law where we thrash through actually how much of a difference is there, how different is it? Because Scotland very firmly rejected the concept of best interests on the basis of, in essence, it was a paternalistic concept, giving rights to decisions made essentially on the view of what the professionals want. England and Wales went with best interests. England and Wales went with best interests, and has in some ways retrofitted onto that test statutorily, retrofitted onto it an approach much less paternalistic, much more closely aligned to wishes and feelings. And actually, I can see on the chat function or the participant list here, a co-author of mine of an article written some years ago where we examined what the place of wishes and feelings were, just for GDPR purposes, and because it's been recording, it's not, I won't mention their name, but it's very nice to see them here. So it's really interesting to me, stress testing, where you start getting into what sort of decisions are in fact made in relation to somebody who doesn't have capacity. One massive difference between Scotland and England, England and Wales has this Section 5 Mental Capacity Act, which Scotland simply doesn't have. Section 5 Mental Capacity Act gives, as Lady Hale says in Re-MN, a general authority to act in relation to the care or treatment of somebody to those caring for him who reasonably believe the person lacks capacity in relation to the matter, and it will be in the person's best interest for the act to be done. Scotland simply doesn't have that. The AWI doesn't provide that form of decision-making structure or that form of structure. And that explains one of the reasons why there is, for instance, a much greater use of Scottish guardianship powers than the counterpart in England, which would be called deputyship here. Because in Scotland, it is much more necessary that there be formal authority for decision-making than there is in England and Wales. There is a certain way of getting around some of that formality in Scotland in terms of medical treatment, Section 47, Adults with Incapacity Act, but outside the hospital setting or medical treatment setting, there just isn't this equivalent. And there's a very interesting debate to be had about which is better. Do you have a piece of legislation which expressly says this is what you can do and you don't need any further formal authority, England and Wales? Do you have legislation which doesn't say that and requires people to go and get formal authority? And what happens if they don't seek formal authority? I'm not suggesting one is necessarily better than the other, I'm just flagging that up. Our NCA mostly applies 16 plus, and there's a very interesting overlap between the Mental Capacity Act and common law to age 18 in England and Wales. Doesn't have the same resonance in Scotland because obviously your age of majority in Scotland is 16 for these most purposes. Our age of majority is 18, and you get into some really complicated and interesting territory which we're grappling with in England and Wales. For instance, in the context of decisions about COVID vaccination at the moment, for instance, what rights do parents have vis-a-vis individual young people? So next slide, please, Murray, if I may. So just kind of carrying on giving the structure, both pieces of legislation, Scotland, AWI, England and Wales, have lasting some form of ability to grant in advance a power to somebody else to make decisions on your behalf. We've got what are called lasting powers of attorney, health and welfare, and also property and affairs. We in England and Wales have got a statutory framework for making advanced decisions to refuse treatment. There is no equivalent to that in Scotland, statutory equivalent. There are endless interesting debates about whether or not that is recognised by the law in Scotland. The general feeling seems to be probably yes, but there's nothing statutory which says so. We've got in England and Wales oversight by a specialist court, the Court of Protection. I would say, having just said I won't say the things which are better about one regime or the other, I would say I think there's something important about the fact we have a specialist court in England and Wales looking at this issue. Not necessarily because they get it right the whole time, but because it means there is a substantial number of decisions in the Court of Protection are reported. And so we've got quite a body of case law from just over 14 years of case law where we can see what the judges are doing. Not all the judges all the time, but we can see that. And I do always find it slightly challenging when I'm engaging in situations in Scotland. There's just simply, for various reasons, not the tradition of reporting cases in that way. And AWI decisions are taken mostly by sheriffs, by the sheriff court, which are just simply not reported in the same way. And they aren't specialist judges in quite the same way as Court of Protection judges are. So there are some interesting things there in terms of just being able to see what the judges are up to, how people are thinking about decision-making capacity. One thing it's important to flag for those of you trying to look across the border to England and Wales, not everything is governed by the Mental Capacity Act or Court of Protection in the context of people who may have potentially impaired decision-making capacity. We in England and Wales didn't introduce the equivalent of the Adult Support and Protection Act that you've got in Scotland, which is a framework to enable, in effect, steps to be taken where somebody may have the ability to make a decision but are vulnerable in some way. We didn't do that. Interestingly, the Law Commission back in the 1990s, when it proposed what became, that after a kind of rather long tangled journey, the Mental Capacity Act, the Law Commission proposed having public law protection for vulnerable adults. There was a whole bit of their report, it just wasn't taken forward. What inevitably has happened is that the courts have realized the world is not divided into people who've got ability to make their own decisions, in respect of whom we can do nothing, and people who lack capacity to make decisions, in respect of whom courts might be able to intervene. And the courts have basically invented in England and Wales, using the High Court's inherent jurisdiction, in other words, a great safety net. If there's a statutory gap, the courts have just filled that statutory gap by developing a jurisdiction which is quite curious in relation to those who've got capacity but vulnerable. Why do I say curious? Well, I say curious because it's at one level wildly inconsistent. We don't quite know how we're supposed to think about people in that position. Are we supposed to be making decisions supporting their autonomy by targeting the individual or individuals who might be coercing them or reducing their ability to make decisions. Well, that might be one strand, but some judges seem on occasion to say, we can make orders directed against the person themselves, the victim potentially of abuse or coercion. That's quite interesting if that person apparently has got capacity. That might be showing us that we need to be thinking differently about the concept of mental capacity, potentially. So next slide, please, Murray, if I may. So let's just stress test the difference between the Mental Health Act and the Mental Capacity Act. So the key differences. The Mental Capacity Act is about somebody's functioning. Can they make this decision? Can they functionally understand, retain, use and weigh the information they need to make the decision? And completely separately, even if they can do that, can they communicate their decision? That communication aspect was always very separate. It was meant to deal with people in locked-in syndrome. Mental Health Act, on the other hand, is about a person's status. Do they have a mental disorder of a nature and degree warranting detention to assess them, detention to treat them? So that's a very different way of looking at things. You can always tell, by the way, if you're engaging with somebody who's very, very familiar with the Mental Health Act and less familiar with the Mental Capacity Act, they start saying things like Mrs. Jones lacks capacity. That's a logically meaningless statement under the Mental Capacity Act, but Mrs. Jones has schizophrenia is potentially a logically meaningful statement under the Mental Health Act. Obviously, the mere fact you've got mental schizophrenia doesn't automatically mean you need to be detained, but you're in a zone where there's a mental disorder you might be considering. So the Mental Capacity Act requires external decisions made to be made in their best interests. So best interests, as I say, has been kind of retrofitted by our Supreme Court to be looking primarily at the person's wishes and feelings. Not determinative, but primarily. Mental Health Act doesn't pretend in general to be anything about best interests. It's not capacity specific, and it's not about the person's best interest primarily. It is just as much, for instance, about potentially the risk the person might pose to other people. And then last difference 3, the Mental Capacity Act covers all potential decision making. We have the most extraordinary range of things which should come before the Court of Protection for consideration, including, for instance, is it in the best interests of a young Muslim man to have his body hair shaved off to comply with the tenets of Islam? I can guarantee you Parliament were not thinking that was something the court might be engaging with, but that's something which the court has thought about. Mental Health Act very much about decisions about care in hospital and medical treatment for mental disorder. So next slide, please. Thanks, Murray. So there are overlaps. So the fact you're detained under the Mental Health Act doesn't exclude the operation of the Mental Capacity Act 2005, for instance, medical treatment for physical disorder. That gets really interesting. If you've got somebody, for instance, who is detained under the Mental Health Act, who needs, for instance, they've got diabetes or a heart condition. What exactly is going on? Is the medication they're receiving medical treatment for mental disorder? Probably not. Is it medical treatment for physical disorder? Potentially. In which case, on what basis is it being provided? You get into some quite challenging and interesting territory there. We then, the number 2 is a bit which just drives everyone wild in England and Wales the whole time. This is inpatient admission to hospital. If you are being admitted as an inpatient and you don't have the ability, you don't have the capacity to consent to your admission, and you're going to be confined upon admission, so in other words, you aren't free to leave and are under continuous supervision and control, Supreme Court, in the case of Cheshire West, which by the way applies just as much in Scotland as it does in England and Wales, Supreme Court says if you're confined and you can't consent, and the state knows or ought to know, you are deprived of your liberty. So there needs to be formal authority to deprive the person of their liberty. And we've got 2 parallel detention regimes here. We've got what are so-called Dole's deprivation of liberty safeguards under the Mental Capacity Act, an administrative detention regime to provide at the moment for inpatient admission for care and treatment to which the person can't consent, and also admission to care homes in those circumstances, and the Mental Health Act, inpatient admission for treatment for mental disorder. Which one applies? This leads to the most complicated and difficult series of discussions about, is this person a physical health patient? Is the real reason they're here? to administer treatment for a physical disorder, in which case we're thinking Mental Capacity Act, or are they a mental health patient, which the very phrase you have to describe someone as physical health patient or mental health patient. I mean, Descartes is responsible for a lot here. I mean, it's bizarre to think of somebody with, for instance, schizophrenia and gangrene. What are they? They're not a physical health patient or a mental health patient. They are somebody who needs help. But the law in England and Wales forces people to try and decide which route to go down. You, interestingly, don't have this problem in Scotland because you simply don't have a standalone equivalent detention regime under the Adults with Incapacity Act. You have a very interesting grey area, a very interesting, well, to be honest, legal black hole. The Scottish Law Commission proposed a regime equivalent to the Declaration of Liberty Safeguards as far back as 2014. I actually remember meeting the relevant people from the Scottish Law Commission at the back of the Supreme Court in Cheshire West, because they came down to see what the Supreme Court was doing. You've never implemented that. You never implemented the Law Commission recommendations. At the moment, it's all got swept up in the Scott Review. But you have a very interesting situation. And by the way, whenever a lawyer says interesting, any health or social care practitioner should always panic. And then we've also got some complex overlaps in the community, number 3, where we've got the Mental Health Act, which is not supposed in general to provide authority to detain in the community, as opposed to provide a framework to enable people to receive care and treatment in the community on, as it were, leave from hospital. And it interacts in some complex ways with the operation of the Mental Capacity Act. These are all things which at one level actually are being grappled with in Scotland, or should be being grappled with in Scotland, but are not brought to the fore in the same way because there is not the same parallel regime to your Mental Health Act 2003 in terms of administered detention. So next slide, please. So we in England and Wales are having a big old discussion at the moment about what we do. We have reviewed our Mental Health Act. There was Sir Simon Wesley chaired an independent review of the Mental Health Act. I should say I was the legal advisor to that. I'm not speaking on the review's behalf, but the review reported in December 2018. The government at the beginning of this year, 2021, published a white paper suggesting, essentially accepting a large number of the review's recommendations, interestingly going further than the review in some areas and not accepting all of the review's recommendations. And they have promised legislation, the phrase is, I think, when parliamentary time allows. What the Wesley review recommended was a number of things, but one of them was tightening admission criteria, essentially making it more difficult to admit people to hospital. And the other thing it really placed a lot of weight on was giving more statutory weight to patients, mental health patients, in terms of getting their views respected, either at the time, or if they've got capacity to make decisions about their medical treatment for mental disorder, or in advance. We don't have in England and Wales in the Mental Health Act at the moment the same that you do in Scotland in relation to your mental health legislation has got a statutory framework for advanced statements. We don't have that. There's something akin to that is being introduced. It's interesting if you just take everything right back to what I was saying right at the beginning of this. If we think 1950s, the Percy Commission were thinking, can we achieve parity of esteem, parity of treatment as between mental health patients and physical health patients? Fast forward to 2018, 2017, 2018. One of the things the Wesley Review ultimately concluded was, in effect, it's very, very difficult to say there can be informal admission to mental health hospitals, because mental health hospitals, by definition, are going to confine people almost invariably. They're going to not get, they wouldn't let the person leave if the team didn't think it was safe. They were going to keep the person, they will keep the person subject to continuous supervision and control. So if you're confined, the only way that you can be there lawfully is if you consent to that confinement. Does that mean that, which means you've got to have the mental capacity to consent? And depending on how beds are working, it is unlikely at the moment that very many people in very many places would be able to be admitted to hospital at a point when they had that capacity to consent. Most people at the moment, and this is not good, I'm just relaying the facts, in most cities, most places in England and Wales at the moment, you would only be able to be admitted to mental health hospital when you're in a period of some considerable crisis, at which point you won't have capacity. So the idea of informality, which was something which was very strong in 1959, Sir Simon Wesley really wanted to see how it was possible to bring back informality. It becomes very difficult to see how that could be the case. And then there isn't total parity of esteem or total parity of legal esteem being suggested by Sir Simon Wesley or then the government in terms of, for instance, decision-making. The suggestion is not that you have the equivalent of the binding advanced decision to refuse treatment under the Mental Health Act as there is under the Mental Capacity Act. If under the Mental Capacity Act, if your advanced decision to refuse treatment is valid and applicable, and the time comes when that decision might be administered, if it's valid and applicable, it simply can't be provided. So Simon Wesley didn't propose that be translated into medical treatment for mental disorder. The government's not proposing it either. And we can have an interesting debate about whether that's the right thing to do or the wrong thing to do. But there are ways in which the mental health legislation will remain distinct from mental capacity legislation. And there's no suggestion that the Mental Health Act be abolished, as for instance Northern Ireland has done. The Mental Capacity Act in Northern Ireland, when it comes into force, fully into force, will have no standalone mental health legislation. Everything will be based on capacity. Both physical health and mental health will be purely based on, do you have capacity to decide upon admission and what your care needs are? If you don't, mental health or physical health, you're thinking about best interest. If you do, there can never be detention or treatment against your will. So Simon Wesley was concerned about that. He thought it was important, and a review thought it was important, to stress test, give a series of confidence tests to see whether that is something which should be suggested in England and Wales. One of the confidence tests being, how is Northern Ireland doing? Which makes it very annoying from a law reform perspective. We're still waiting for Northern Ireland fully to implement. And I will be fascinated to see what the Scott Review suggests in due course in Scotland. Is the Scott Review going to suggest the fusion of the law in Scotland to abolish the Mental Health Act and abolish the Adults with Incapacity Act and most solely, or expand the Adults with Incapacity Act to address those who might be in mental health crisis? We'll see. I should just lastly say the Mental Capacity Act is being amended to deal with some of the, in cutting a very long story short, the Mental Capacity Act is being amended to deal with technical deprivation of liberty problems that we've got, mainly arising out of the fact that the Supreme Court made clear in Cheshire West just how wide the scope of deprivation of liberty goes. It's not just institutional, it could be in people's own homes. It could be in supported living placements, it could be in all sorts of areas. And our current regime simply doesn't provide for that. And so one of the things that the Mental Capacity Act is being amended to do is provide ways for checks and balances to happen in any setting. So next slide, please. So I wanted to zoom out just for the last bit before we get into a discussion, because I did want to leave a decent amount of time for discussion here. I wanted to zoom out the last bit to place everything in a bigger context. So one thing both of us are grappling with in England and Wales and in Scotland is what the Convention on the Rights of Persons with Disabilities says. So the Convention on the Rights of Persons with Disabilities, for those of you who are yet to be familiar with it, is an incredibly important UN convention, which the UK signed well over a decade ago now, actually, and by which the UK committed to bring its laws, practices, and policies into alignment with the goals of the convention. And the very simple model of the convention is persons with disabilities, as they're described there, saying, oi, the laws simply don't work. We are told we are able to enjoy our fundamental rights, rights to liberty, right to life, right to health, things like that. We're told we enjoy those rights, but because of the way in which societies are set up, we simply can't enjoy those rights on an equal basis with others. Please go away and try again. And that's really what the CRPD is doing. It's an incredibly important convention. It's a state level convention, so the UK signed up to it at a state level, but it's not domesticated. It's not part of the law in England and Wales, or indeed the part of the law in Scotland. And what is challenging in this area is we've got the CRPD, and then we've got the CRPD committee. So that's the treaty body appointed by the UN, almost exclusively made up of persons with disabilities, disabled people. And there's an enormous argument going on as to whether the CRPD committee says more, or says that the convention says more than it actually does. So just to take two examples, both extremely pertinent in the zone I'm talking about. The first is, has the UK, by signing up to the CRPD, committed itself to saying we will never deprive anybody of their liberty in the mental health or indeed mental capacity context? The UK certainly doesn't think it does, and doesn't think that Article 14 of the CRPD, which is the right to liberty, has committed itself to that. Doesn't think that's what it says. The CRPD committee says Article 14, guaranteeing the right to liberty on an equal basis for everybody, including those with disabilities, means you are never allowed to deprive somebody of their liberty in the presence of disability. The UK would say, and then interestingly, the Strasbourg Court, the European Court of Human Rights, interpreting Article 5 of the European Convention on Human Rights, our regional version of the right to liberty, interpreting that in light of what the CRPD committee have said, the UK and European Court of Human Rights says, no, that's not in fact what is going on. It's not illegitimate deprivation of liberty on the basis of disability. It's just not what's going on. Yes, the person may have a disability, for instance, an ongoing mental disorder, but the deprivation of liberty is not on the basis of disability. It's on the basis of the risk that the person poses to themselves or to others. And to date, the CRPD committee has not managed to convince either the UK courts or the European Court of Human Rights that the CRPD in fact means deprivation of liberty is unlawful in those situations. The CRPD committee also hasn't managed to convince the Human Rights Committee, which oversees the UN International Covenant on Civil and Political Rights, that that's the case either. Because the Human Rights Committee says that the right to liberty in the ICCPR doesn't mean you can never deprive of liberty in the presence of mental disorder, say. It says it's got to be a last resort, and it's properly got to be based on a proper assessment of risk. So that's one aspect. Both England and Wales and Scotland are grappling with the implications of that in terms of law reform. The other last aspect is that the CRPD committee says, and a really important debate about Article 12 of the CRPD, which enshrines the right to legal capacity. The CRPD committee says two things. One, you are not allowed to proceed on the basis of a conception of mental capacity akin to that we've got in England and Wales and that which you've got in Scotland. In other words, mental capacity, the idea that somebody doesn't have the ability to make their own decision, is a discriminatory concept, which discriminatorily applied and should not be used as, in effect, to give the definitive answer, do I take this person's no as determinative? They say that's illegitimate. And they also say that any decision in relation to somebody with disabilities must always be based on their will and preferences. This is not what the CRPD itself necessarily says. It's certainly what the CRPD committee says it says. And again, both in England and Wales in the context of the Mental Capacity Act, and Scotland in the context of thinking about, for instance, the Adults with Incapacity Act, people are having to grapple with what exactly does this mean? What exactly has the UK signed up to in terms of the CRPD? And I did just want to flag that case of AMV in Finland, because the European Court of Human Rights was presented with a very strong intervention in a case by the fantastic Mental Disability Advocacy Centre now called Validity, saying, when you come to interpret Article 8 of the European Convention on Human Rights, which includes the right to private and family life and the right to autonomy, you are bound to follow what the CRPD committee says. And you must proceed on the basis of the person's will and preferences. And the European Court of Human Rights says, thanks very much, For Article 8 purposes, we just don't agree. We don't think we're bound to interpret it that way. We think, taking into account the CRPD as a relevant international instrument and taking into account the CRPD committee's views, what we're bound to do is think about Article 8 and ensure there's proper respect for the person's rights, will and preferences. And AMV in Finland was a case where the individual in question was saying, I want my guardian, effectively you can think Scottish guardian, English deputy, to be discharged because they're not letting me do what I want. What I want to do is go and live in the top of Finland with people who had previously been my foster parents. And the guardian is saying, no, you can't do that. The European Court of Human Rights says, we don't think that in fact AMV had the mental capacity to make this decision. So they think mental capacity is a legitimate basis upon which to proceed. And we think that the process as a whole in Finland, where this person was able to stress test their argument and say that the guardian should have done something different, properly respected their rights and preferences. So the European Court of Human Rights said that a model which looks very, very much like the Mental Capacity Act in England and Wales and very, very much like the AWI in Scotland is legitimate. We're going to no doubt see evolution as the European Court of Human Rights talks to the CRPD committee, as it were, carrying out this dialogue over time. And for what it's worth, I think it's very likely in the fullness of time, the European Court of Human Rights will say, you are not allowed to deprive somebody of their liberty unless they lack capacity to make the relevant decisions. So I think, for instance, in England and Wales, our Mental Health Act, which has the ability to deprive of liberty and indeed treat in the face of capacitous refusal, I think in due course the European Court of Human Rights will say that's unacceptable. It could only be in the context of somebody lacking capacity to make a decision. That's my kind of projection forward. But I'm going to be super interested to see what the Scots review comes up with in the context of thinking about how things work in Scotland. So very lastly, my last slide, please, Murray, and I'll just give some resources and then I will shut up and then we can have some questions. If you're interested in kind of more resources about English stuff, the top link there is my chambers. I'm a member of Barristers' Chambers called 39 Essex Chambers. We do a lot of work relating to mental capacity law and we publish a mental capacity report most months. The most recent one came out last week. You can subscribe to it for free there. And all the cases I've talked about today, you can find in our case law database we keep there. I would just then also just flag the Mental Health and Justice Project is a big academic project I've been working on for some time, led out of King's College London. It's coming to its end, but it's looking at a lot of things under the umbrella of mental health and justice and really trying to grapple with how do you think about making decisions in relation to people or supporting people to make decisions in a way which we sometimes say balances empowerment and protection. And then lastly, my website, Mental Capacity Law and Policy, there's a lot of stuff on there about English issues, but also when there are interesting things relating to mental capacity more broadly defined, I do stuff there. So I think that's my 45 minutes, which is what I was aiming for. So I think we can stop sharing the slides now. Thank you so much, Mary. And then I'm really happy, if we stop recording, I'm very happy then to take questions in which